With your due permission, ma'am, shall we start the proceedings?
Yes, you please start.
Okay.
Yes, Nandini, you can start.
Yes, ma'am. As a student of IPR, I firmly believe that the future belongs to those who innovate and the law belongs to those who protect innovation. Good evening, everyone. It gives me immense pleasure to welcome you all to the Collaborative Conference on Global Convergence on Intellectual Property, CGCIP 2026, on the occasion of World IP Day, celebrated on April 26 every year. This conference is organized and coordinated by the Center for Intellectual Property Rights, Vivekananda School of Law and Legal Studies, WIPS-TC, in collaboration with the University of New Hampshire, Franklin Pierce School of Law, Concord, United States of America, under the Memorandum of Understanding signed with the university to strengthen this academic collaboration even more. I am Nandini Achura, the executive member of Center for Intellectual Property Rights, VSLLS WIPS TC, and it is my privilege to warmly welcome all our honored dignitaries, esteemed speakers, academicians, professionals, delegates, research scholars, and all the participants joining us from across India and around the globe. Today, we mark the formal commencement of this distinguished collaborative conference at international level, conducted under the esteemed guidance of Dr. S.C. Vatsar, founder and chairman, WIPS TC, Mr. Suneet Vatsar, vice chairman, WIPS TC, Professor Dr. Rashmi Salpekar, Dean, Vivekananda School of Law and Legal Studies, WIPS TC, Professor Courtney Brooks, Dean, UNH Franklin Pierce School of Law, USA, Ms. Sarah Donor, Assistant Dean, UNH Franklin Pierce School of Law, Dr. Nipun Gupta Jain, Associate Professor, Convener for Center for Intellectual Property Rights, Vivekananda School of Law and Legal Studies, WIPS TC. And last but not the least, Dr. Tanvi Sehgal, Assistant Professor, Co-Convener, Center for Intellectual Property Rights, Vivekananda School of Law and Legal Studies, WIPS TC. With this note, we are pleased to present a short glimpse of the esteemed institutions whose collaboration has made this conference even more possible. We begin with the University of New Hampshire Franklin Pierce School of Law, USA, globally recognized for its excellence in intellectual property education and research. I would like to request the organizing team to please play the video.
Hello, and welcome to the Collaborative Conference on Global Convergence on Intellectual Property 2026. My name is Sarah Dorner, and I am the Assistant Dean for Graduate Admissions and International Outreach at the University of New Hampshire Franklin Pierce School of Law. I want to give a special thank you to Vivekananda School of Law and Legal Studies and their Center for IPR for their partnership on this initiative, especially to Dean Rashmi, Dr. Nipun Jain, and Dr. Tanvi Sehgal for your support of this event. Professor Rosen and I are thrilled to be a part of it, and I am sorry that I cannot join you live today, but I'm sending this video to share a little bit about the University of New Hampshire Franklin Pierce School of Law and our world-renowned program in intellectual property law. Our law school is accredited by the American Bar Association, and it was founded over 50 years ago by inventors and entrepreneurs with a strong focus on IP from its inception. The school is located in the state of New Hampshire, so just 1 hour north of Boston, Massachusetts, in the northeast of the US. It's a beautiful state, consistently ranked the #2 state to live, #1 for safety, and a beautiful place to appreciate nature and all 4 seasons. As I mentioned, our school is really renowned in intellectual property. We have an incredibly comprehensive course list and courses in IP and technology and IP-related courses. Many of our faculty have IP expertise. We are proud to be the largest academic IP library in the Western Hemisphere. Our library is one of only 3 global IP research facilities around the world, and our IP Mall is the oldest open access IP research site on the web. We have more than 7,000 alumni living in over 80 countries, so practicing worldwide. Our students get the chance to have some hands-on experience while they're here with us through our intellectual property and transaction clinic, where they might get a chance to take on real casework under the supervision of a licensed attorney and even get a limited license to practice before the US Patent and Trademark Office. And then in addition, we offer a number of immersive courses to prepare students to be practice-ready professionals when they graduate. In the past, we've taken students on location to places like Silicon Valley, where they met with leaders from Amazon and Google, Apple. We've gone to Las Vegas for courses, as well as Hawaii for a course in partnership with the World Intellectual Property Organization. We are really pioneering IP for the digital age. We offer a number of courses related to patents and copyrights and trademarks, but take a broader approach and also explore areas such as data and privacy, health law and biotech, artificial intelligence, sports, entertainment, and media law. The school is truly a hub of IP activity. Our Franklin Pierce Center for Intellectual Property sponsors a number of speakers and events throughout the year. And you can see here just a snapshot of some of these events that we've held in recent years. I would say each semester there's probably 3 to 4 new speakers that come and meet with our students. We have a number of different degree programs that are focused in intellectual property. In addition to the traditional 3-year Juris Doctor program here in the US, we also offer an advanced standing JD pathway that allows foreign trained attorneys to earn their JD in just 2 years. We offer a hybrid Juris Doctor that takes about 3 to 3.5 years to complete. And students in this program can specialize in IP, technology, and information law, or in health and life sciences law. We also have an LLM specialized in intellectual property that can be completed in person or online, a master in IP for students without a legal background but working in law adjacent roles. Again, this can be completed in person or online, and then a shorter term graduate certificate where students can earn expert credentials without completing a full degree program. And this is also specialized in IP and has in-person and online modalities. Adjacent to our IP program is our legal graduate program in commerce and technology law. This program also offers an LLM, a master, and a graduate certificate, and it looks at issues facing new business and e-commerce in the global information age economy with a focus on digital and privacy law. I share here just a sample of some of our IP technology and IP related courses. This list is constantly evolving from year to year. We're kind of taking away classes, adding new classes. So I share this as a sample of the depth and breadth of the courses that we have to offer in the IP space. We have a number of student organizations for our students to participate in when they are with us in person or in our online programs. And a significant number of these are specific to IP as well. So much about the US law school experience is not just what happens in the classroom, but outside of the classroom as well. So this is a sample of some of those IP student organizations, our IP Law Review, Sports and Entertainment Law Society, Master of the Trademarks, and a Student IP Law Association, to name a few. We also want to make sure that our students that come to join us get a chance to experience American and New Hampshire culture. So we'll take them apple picking in the fall, we'll go snow tubing in the winter, we'll have a special meal to celebrate Thanksgiving, and then we'll go to our main university campus to see an ice hockey game as well. So just a few examples of some of the fun activities that students get a chance to engage in while they're here with us. And then finally, I'll mention our Intellectual Property Summer Institute. This program is on pause this coming summer, but we are already preparing to host it again in June 2027 with a focus on sports law. So I'll leave that information here. I invite you to reach out to me or to Professor Rosen for more information about that program and to get on our list to learn more as we prepare for the June 7th to 10th, 2027 Sports Law IP Summer Institute. My contact information is here, and then certainly it will be available through the program as well. And I invite you to reach out with questions about our school and about our programs, and I will be happy to connect. Again, I am sorry that I can't be there with all of you online. I wish everyone a wonderful experience at this conference. It's been a real joy to partner with Vivekananda on this project, and I'm sure it will be a great success. So thank you very much and enjoy the conference.
Thank you for such an informative video for all the IP enthusiasts. We now present a brief glimpse of our institution, Vivekananda Institute of Professional Studies Technical Campus, its School of Law, Vivekananda School of Law and Legal Studies, and its Center for Intellectual Property Rights, which continues to foster innovation, research, and academic excellence in the field of intellectual property. What a wonderful beginning to this conference. We shall now proceed with the formal inaugural session. It is now my privilege to invite our distinguished keynote speaker, Professor Vivi Rosen, Associate Professor and Faculty Director, Franklin Pierce Center for Intellectual Property, Concord, United States of America. Professor Rosen is a respected scholar whose contributions to intellectual property discourse are internationally acknowledged. He is having a plethora of publications in the fields of patents, copyrights, trademarks, American legal history, and bankruptcy. May I respectfully invite you, sir, to kindly address the gathering?
Thank you so much, and good morning and good evening to everyone. I'm going to have a little bit of a slideshow here, so I will show you some of that. There we go. So this is a project that I've been working on for a number of years now, as we've seen artificial intelligence really continue to rise in prominence. And my core methodology when I approach a question is very much to try to look back to tell us what we can learn about the future. So we're going to start in the past, go to the present, and then look to the future with this talk about AI and what it has meant, does mean, and will mean in the future for intellectual property law, especially for copyright. So one of the interesting things that I found, I'm not the only person to notice this, was that in 1965, the United States Copyright Office put in an annual report of its examining division this, and there's a shorter version of this in the main Copyright Office annual report, which says, as computer technology develops and becomes more sophisticated, difficult problems of authorship are emerging to confront the examining division. We have in past years received an application for registration of a musical composition created by a computer. This year, copyright was claimed in an abstract drawing and compilations of various kinds, which were the work of computers. It is not unreasonable to expect that the number of works approximately produced or written by computers will increase. In many cases, the application will not reflect the true nature of the authorship, and registrations will be made that would not be if the actual facts have been known by the examining division. The problem is complicated by the fact that we cannot take the categorical position that registration will be denied merely because a computer may have been used in some manner in creating the work. After all, a typewriter is a machine that is used in the creation of manuscript, but this does not result in the manuscript being uncopyrightable. So this is the key part. The crucial question is whether the work is one of human authorship, with the computer merely being the instrument, or whether the creation is conceived and executed not by man, but by machine. So I tried to find who was still around, who remembered this. 1965 was a while ago. It's hard to find people. The only thing I really learned is that Barbara Ringer, who was also the main author of the United States Copyright Law in 1976, also wrote this. That's the only thing I was able to really confirm. So, and we see that this last line, that the crucial question is whether one of human authorship or a computer merely being the instrument, it largely remains the standard of the United States to this day. And there really hasn't been that much change. And I think it largely reflects the standard in a lot of other countries as well. So I wanted to know, what work were we talking about here? What was the journey to getting to this point, and what happened after that? A bit of a prologue before that. In the United States, we have two cases that really explored the contours of what copyright allows. Burrow-Giles versus Cerrone is the so-called Oscar Wilde photograph case, where Napoleon Cerrone took this photo of Oscar Wilde. Burrow-Giles used it to advertise their department store. Cerrone sued. The key question is whether a photograph, which, mind you, this was in the early 1880s, so Cerrone was the director, but he was not operating the camera, whether or not there was copyright protection to Cerrone for the photo, and whether, generally speaking, a photograph was a writing within the meaning of the United States Constitution. The U.S. Supreme Court said yes to both, said that as long as Cerrone was the mastermind and as long as the camera was merely used as an assistive device, that it could be protected by copyright. The other case, a less known case called the trademark case, it's from 1879, held that a simple trademark could not be protected under the Copyright Clause of the United States Constitution. And they said that while the word writings may be liberally construed, as it has been to include various things, it is only such as they are original and founding the creative powers of a mind. And the court held the actual trademark in that case was okay whiskey, and they said that is not enough. It has to be an original writing founded in the creative powers of the mind. So that's our background. I then went off on an interesting tangent. I had a chat with John Baumgarten, who was general counsel of the U.S. Copyright Office in the 1970s, and he indicated I should be looking at randomness and the use of randomness in authorship to better understand the context of an AI conversation. Now, on the one hand, randomness is interesting because it's not AI per se, but equally, it does create this issue of mediated authorship, where you have an author who might not actually, who is not necessarily the creative power behind the work. The author might set up the circumstance, but the expression is not the result of the author's intent necessarily. So there's a few works where there were serious attempts to register it. I'm not sure if people here are familiar with the composer John Cage. John Cage was a eccentric, I think it's fair to say. This is his most famous work, 433. 433 is a completely silent piece. In 433, the performer, if you will, gets on stage, opens a piano, sits there for 4 minutes, 33 seconds, closes the piano, and walks off the stage. Is that registrable for copyright? And what exactly did John Cage author? You might note this is the actual copyright deposit 443 from the Library of Congress. The bottom says the work may be performed by any instrument or combination of instrumentalists and last any length of time. So he is not claiming even silence for that exact length of time. For those of you who are wondering why 433, 273 seconds, or rather minus 273, is absolute zero. So is this copyrightable? The U.S. Copyright Office really wrestled with this. This was actually published by Henmar Press. This was not merely an unpublished work, and it was actually quite a sensation when it came out in avant-garde circles. So the U.S. Copyright Office looked at this, and it turns out, and this is what John Baumgarten pointed me to, Dorothy Kezia was the head of the music division at the U.S. Copyright Office at the time, and she wrote an article that actually describes this. And what she says is, it can also be argued that certain indeterminate works may sufficiently fix the original musical sounds to qualify for Class E registration. Class E was music under the U.S. Copyright Law of 1909. Those works which carry indeterminacy to its extremes, works for which there is really no score at all, do not qualify for registration as musical compositions because they do not fix a sufficient amount of the original sound of a piece. Although registration could be made for such works as books in Class A, they were published with notice. No registration would be possible if the works were unpublished due to the vagaries of the 1909 U.S. Copyright Act, which did not allow for unpublished text. In other words, 433 was ultimately registered as text. You see, this is registered as a book under Class A, but not as music. And you can see, if you look at the bottom right of the second page, that although the application was received in 1968, 2 copies and the fee were received in 1965, which is a bit of a clue. But actually, the U.S. Copyright Office spent almost 3 years debating whether to grant copyright to this before they ultimately accepted it as a text. And I believe, although I can't prove, that they instructed Cage, and really his publisher, to send a new registration. So we see here, there's a willingness to accept registration for works that may not have complete authorship. But what exactly did they accept? I'll go back and show you. Only the text. They accepted this text for registration. They did not accept this as music. So there is perhaps an analog here, and I argue this, that these are the prompts that you would use to create an AI work, and those may be registrable. But the actual output, And Cage made clear the output is not just silence, it was the sound of the audience around, the sound of silence that was that was the music. That is not copyrightable because John Cage was not the author in any meaningful sense of that silence beyond instructing them to be silent. In addition to this, I was able to find a little bit of registration material in John Cage's papers, which are now at Northwestern University. In this case, he wrote another piece called Renga, an Apartment House, 1776. And Cage actually argued that no, there is substantial authorship here. And you have Mildred Henninger, who was a bit later the head of music at the Copyright Office, saying, I heard this on the radio and I couldn't tell what the music was. Can you please clarify? Peters, through Cage, responded explaining what the music was, and the Copyright Office ultimately registered it. There were some other works, I'm sorry, involving indeterminacy. This one was actually litigated very briefly. Abraham Kamenstein was registered at the U.S. Copyright Office from 1960 to 1971. Decades later, I was also honored to serve as the Abraham Kamenstein Scholar in Residence at the U.S. Copyright Office. So Armstrong Cork Company attempted to register this flooring material for copyright. This was made by dropping pieces of that material, you can see, into a substrate, and each piece was a little different. Randomness dictated the output. The Copyright Office specifically declined to register it, saying that the output was indeterminate, that they were free to register this exact tile rather, but they were not free to register the pattern generally, or the pattern was random. Armstrong briefly attempted suit. When it became clear that the trade secrets would have to be revealed as part of a lawsuit, they withdrew the lawsuit. So even though this bears a copyright notice, it was never registered for copyright. All right. That's all the randomness. What about early AI works? What were the works they were talking about? One of them was the artwork, and I've been able to determine this, was Gaussian Quadratic by A. Michael Knoll. In the early 1960s, Knoll was an intern at Bell Labs in New Jersey, and he was working with a microfilm plotter, one of the first of its kind. And in addition to using it for scientific purposes, after hours, he was playing with it a little bit, and he said, what would happen if I wrote a program to generate random lines? And he wrote a program that generated these random lines following Gaussian quadratic equation. And when it came out of a plotter, he said, "Oh, this is beautiful. I think this is art." It reminds, and someone else commented it reminded him a little bit of Picasso. So this became one of the earliest works in computer art, really produced in the United States and really generally. In 1965, there was an exhibit of computer art in New York City, and this was one of the works that was illustrated. Now, Bell Labs, which is was part of AT&T and a serious business, was a little concerned about being seen as frivolous, so they encouraged Knoll to get the copyright under his own name, not as employee of AT&T Bell Labs. So he did so, and he writes as at first the Copyright Office refused since the machine had generated the work. But he explained that a human being had written the program and incorporated randomness in order. They again refused, saying randomness was not acceptable. He finally explained that while the numbers generated by a program appeared random to humans, the algorithm generating them was perfectly mathematical and not random at all. Once Knoll was able to explain that the program was not actually random, they accepted it. Lejarin Hiller, this is one of the, I believe, the only current in-print CD of his works, was a computer scientist, chemist, and composer at University of Illinois and later University of Buffalo. Incredibly early, in 1957, he published the ILLIAC Suite. He wrote this on the only computer at University of Illinois around 1952, an actual vacuum tube computer. The four movements of his ILLIAC Suite for string quartet are actually called experiments. They are written by computer. If you read the introduction to the ILLIAC Suite, it says in no uncertain terms it was written by copyright, by computer, pardon me, but the US Copyright Office accepted it anyway. My working theory is, frankly, that the Copyright Office saw a piece of music, New Music Edition was a well-known avant-garde music publisher, and the Copyright Office simply accepted it without too much quarrel. The Copyright Office revised registration in 1965. I don't believe that's a coincidence. They very rarely revise registrations. I think they looked at it again when the AI issue became a bigger deal. The Computer Cantata, a few years later. Interestingly, this not only includes computer-authored music, it includes computer-authored vocal parts as well. Computers of the 60s were not powerful enough to generate words, so they generated phonemes. Finally, what are those compilations? Well, phone books. In the mid 1960s, again, AT&T was experimenting with using computers actually for directory assistance. But once you've done that, they did a pilot program to have a computer create from scratch the phone book for Staten Island, which is one of the boroughs of New York City. Going into the 1970s, the issue continues. And in the late 1970s, as the 76 Copyright Act was approaching completion, computers were getting more and more powerful. And it becomes clear to Congress they need to address computers, but they say we can't do this now. We spent all the time getting copyright law passed. We don't have time for it to deal with computers. So instead of doing a problem from scratch, they created a commission. This is called COMPTU, the Commission on New Technological Uses for Copyrighted Works. You can read the report of the commission and all of its transcripts online if you're interested. The final report broadly endorses the U.S. Copyright Office approach. They say that no special problem exists concerning concerning computer-authored works. The law adequately covers any questions involved, and no action by Congress is necessary at this time. In the hearings, Melville Nimmer, who some of you may be familiar with, he's the author of he is now passed on, but his son now edits it, the leading treatise on copyright law in the United States. And he said, what I'm trying to do is focus on the extent to which this brave new world simply presents new copyright problems, to discover the extent to which they are simply the same copyright problems in somewhat different packages, and really no more difficult than existing copyright problems. One question raised had to do, I think, at least by implications, with the copyrightability of works created in part by machine. That is an interesting question, but I don't think one that is terribly difficult. And then he says after that, I could be wrong. So far he's saying, listen, the line from 1965 works. The question is whether the human or machine is a mastermind, and that's the line. In 1984, Ractor, an early text generation engine, and amusingly, one that was supposedly created to mimic someone who's insane, wrote a book of prose and poetry called A Policeman's Beard is Half Constructed. This says on it, this is the actual registration, nature of authorship for William Chamberlain, program computer to create entire text. The U.S. Copyright Office granted this without any caveats. I don't know why. I do have reason to believe the U.S. Copyright Office was in a state of some disarray in the early 1980s, and that might be why. In 1991, WIPO ran a symposium on the IP aspects of artificial intelligence. At this point, you already have Professor Arthur Miller of Harvard saying the issue of AI authorship is old news. We've been dealing with it for decades. What's the problem? Which is, I think, sort of fascinating to see. The whole conference proceedings are really rather fascinating to see what was going on with AI and intellectual property in what's now 35 years ago. Also, in the early 1990s, I'm not sure if people are familiar with the author Jacqueline Suzanne. She's best known for her book Valley of the Dolls. So Scott French programmed his Macintosh computer to write a imitation of Jacqueline Suzanne's work. The U.S. Copyright Office, you can originally say that Scott French claimed the entire text, but that was amended. The registration now says some original text and some computer guided text. So the Copyright Office required that. You can see more required amendments to exclude AI authorship. And here in 1996, where David Cope originally tried to register a monograph on a computer system for emulating music using a computer. The U.S. Copyright Office required amendment and it simply said entire text of monograph now. So a modified registration. Recently, the issue has come up much more, as I'm sure many of you are aware. I don't need to remind you all of these, although I'll mention a few. Interestingly, many of you are probably aware of this, but Ankit Sani attempted to register this work, Suryaast, which was a work that it was his photo of a sunset, and he even told this AI called Raghav to make it look like Starry Night, which it did. He tried to claim the output, and the Copyright Office said, listen, you're allowed to claim your original photo, but where the AI generated this output, it cannot be registered in the United States. And this is from the decision of the U.S. Copyright Review Board at the Copyright Office. I will note that, as I understand it, the Indian Copyright Office has registered this work, causing some consternation. Now, I believe, but I am open to correction on this, that the Indian Copyright Office did not necessarily do an evaluation of a work for copyrightability purposes, and it might affect registration and why it was granted. But this was denied. In 2025, the U.S. Copyright Office came out with a report on AI authorship. And they said questions of copyrightability and AI need to be resolved pursuant to existing law without the need for legislative change. And they said current tools basically work, and copyright does not extend to purely AI-generated material, and human contribution needs to be analyzed on a case-by-case basis. So prompts alone do not provide sufficient control for the final output. The office is a bit unclear whether the prompts are protectable in and of themselves, but I don't think people really want that, honestly. The case has not been made for sui generis protection or anything like that. So what's happening now? There's a number of cases. Stephen Thaler attempted to register his work, A Recent Entrance to Paradise. And both the U.S. Copyright Office rejected it. The District Court and Circuit Court in D.C. both affirmed that rejection and said it was proper, that his computer called Debus cannot be an author. The U.S. Supreme Court, only about 2 months ago, declined to hear the case. So that case is not going to be heard, and that leaves the D.C. Circuit's opinion in place. There is another case currently moving forward, Allen versus Perlmutter. In that case, Allen has created a work with about 600 prompts, and he then edited the work to change it and make it, and he attempted to register that. The Copyright Office said no. It is currently on summary judgment before the District Court in Colorado, which is where Allen lives. In practice, the U.S. Copyright Office will accept registration of works containing AI authorship if that AI component is disclaimed. Registrant does not need to specifically identify what the AI authorship is, but may be asked to indicate it generally. And I can tell you, in 2025, over 5,000 works containing AI authorship in some way, where the AI portion was excluded, were registered following this procedure. So this is going to be the procedure going forward. So what are 6 lessons we can learn from this? And I've broken those down. The first one is simply the Copyright Office got it right. When this issue was raised, Barbara Ringer was the head of the examining division, and she took the issue very seriously. I spoke to Art Levine, who was a retired partner at Finnegan, and he was actually at the examining division at the time. He says he remembered that she took it personally and worked on it. This was something she specifically focused on. At this time, she had really completed the process of drafting what would become the 1976 Copyright Act. She was profoundly conversant in the structure of copyright at the time. This might just be the case where the right person got the question and answered it correctly. That might be all we have. That's fine if so. Second one, register the prompts. Well, using text for registration for a new technology is hardly new. It's, of course, the same approach used for computer programs, where the Copyright Office was confused for years what a computer program was, until they said, oh, this is text. We can register text. That's easy. And that's what they do. The actual origin of computer program copyright was when a law student at Columbia University published a program in the law school student newspaper and then sent that in for registration as a contribution to a periodical. And the Copyright Office immediately said, "Of course you can register a contribution to a periodical. And you clearly wrote this. The fact that it's a computer program is okay." So, it's the actual authorship of the AI work. So the prompts are the actual authorship, right? That's what you actually wrote in creating the AI work. That is your actual authorship. I think aleatory music, this avant-garde music we talked about, provides another real precedent where we can say you can register for prompts just like computer code or instructions. Now, this should probably be limited to cases where there's no other input or could be combined with a thin copyright for post-generation edits. So this may either be part of a suite of protections, sort of like an album where you have protection for the music and also the album art, or it could just be the protection in and of itself. Another thing to consider is that lawyers I think we're very good at thinking inside the box about finding existing rules and systems that apply to the situation at hand. We're not always good at thinking outside the box. We're not always good at thinking of new solutions. And I think it's something to think about to say, why are we not able to think of a new solution? We can only apply existing solutions. But I do think it's something worth considering. Well, what about the rule of doubt? I don't know why, but I love this guy's expression. So the rule of doubt has long been used for computer software. If a Copyright Office cannot tell from a deposit whether the work is registrable for copyright, the rule of doubt may be appropriate. Now, in recent years, it's only been used for computer software. But in the past, it was used much more broadly in situations where registration was questionable as sort of a rule of lenity. I've also found, actually very recently, that from 1978 to 2008, if the Copyright Office registered a work under the rule of doubt, they did not so indicate it on registration. It's only in the correspondence. So if you're litigating a copyright in the USA that seems questionable, you should try to figure out if it was registered under the rule of doubt and that's not indicated. So one advantage of this is it allows the U.S. Copyright Office from being too involved in very fact-specific determinations. Is simply a way of indicating a question about it. This is actually mentioned in the U.S. Copyright Office Compendium of Practices, Compendium 607, where they say on occasion the office may register a claim to copyright even though the office has reasonable doubt as to whether the material constitutes copyrightable subject matter. This is known as a rule of doubt. The rule notifies the claimant, the court, and the general public that the office is unwilling to grant a presumption of validity of certain aspects of a claim. In exceptional cases, the office may apply the rule of doubt if the office has not taken a position on the legal issue. So I think this is very appropriate for AI. I think this is on the books already. We can use it and we should. The copyright is old. I mean, if you look at certainly the US copyright system, it's been modernized several times, 1790, 1831, 1909, 1976. But if you look at what it is under the hood, it's really fundamentally a case where they've taken the Statute of Anne from 1710 and modified it to fit times. But is it getting a more and more awkward fit as we get into the era of technology with sound recording and moving pictures and computer programs, and now computers actually generating work? I think it's worth asking. Copyright has been stretched and bent for a very long time. Is AI where it breaks? Finally, is it possible for
Professor
something
Zuvi,
bigger?
good evening, Professor Zuvi.
Wrap it up.
Actually, yeah, we are having Honorable Justice C. Hari Shankar here in the meeting, Delhi High Court judge. So if we can just we can have.
Please, just a minute. Please let
Yes,
Professor
sir.
Rosen continue.
Continue, sir.
As it is, I don't have
Yes,
as much
sir.
time as has been allotted to me, so I'm also enlightened by what he's saying. Let him finish what he has to say. No hurry, Professor Rosen. Please
Thank you,
continue.
sir. Thank you so much, sir.
Okay. Well, thank you very much, Your Honor. And I'm actually near the end anyway. But I'm glad to get to this. Is there something that tells us about authorship and indeed about humanity and what we value about copyright here? I mean, the U.S. Constitution says, but for progress of science and useful arts, given to author certain protection. And I think that's not just a U.S. principle. There is something bigger about why copyright matters. And that is, there is something valuable and important in human creativity. And I think Jane Ginsburg has a wonderful point, which is that a machine may be operated by someone with a mind, it does not have a mind of its own. AI can turn out impressive author-like works, but grandiose projections notwithstanding, it is not sentient. There is this humanism central to copyright, and we need to protect it and bear it in mind when we're dealing with this. We shouldn't just be mechanical and say, yes, this looks like a copyrightable work. We have to understand that there is a humanism inherent in copyright, which is worth protecting. And my last slide from Commissioner John Hersey, this is from his dissent in Cantu from 1978, says, a society that accepts in any degree such equivalences of human beings and machines must become impoverished in the long run, and those aspects of human spirit which can never fully be quantified and which machines may be able in some distant future to linguistically understand, in quotes, but will never be able to experience, never be able to bring to life, never be able, therefore, to communicate. Those aspects includes courage, love, integrity, trust, the touch of flesh, the fire of intuition, the yearning and aspiration of what poets so vaguely and so persistently call the soul. A bundle of qualities that we think of as being embraced by the word humanity. Thank you so much.
Thank you. Thank you so much, Professor V. Rosen. It was indeed an enlightening session for all of us. Now, with this, I may request Honorable Justice C. Harishankar, sir, that kindly enlighten us. And we are extremely thankful and we are welcoming you on behalf of Vivekananda Institute of Professional Studies. Over to you, sir. Thank you. Please.
So good evening, everyone. And that was an extremely enlightening address by Professor Rosen. You see, when you ask a sitting judge to address a conference like this, you are in a different paradigm altogether. Right? We as judges normally deal with various jurisdictions. Unlike many of the courts abroad or many of the countries abroad, we rarely have situations where a judge in a court in India has a chance to deal with intellectual property matters for an extended period of time. Countries outside will probably find it very difficult to understand the manner in which our judiciary functions. For example, in our High Court, each of us has a daily cost list of close to 100 cases, right? And on an average, we try and dispose of 7 to 8 to 10 cases a day. And these 100 cases are not the 100 which will be on the next day. So in a week, for example, an ordinary High Court judge would be having on his list perhaps around 700, 600 cases which he deals with. And with that kind of backlog and that kind of work pressure, it is impossible to have dedicated courts dealing with any subject matter. So, for example, in our High Court, and intellectual property being one of the most emerging and most important fields in modern commercial law. We had an intellectual property. Now we have an intellectual property division in many high courts. I think the Delhi High Court was probably the first to introduce it. And but our intellectual property division, for example, has 2 judges sitting singly hearing IP matters. And those IP matters would be covering the entire IP spectrum: trademarks, copyrights, patents, designs, geographical indications, and even to some extent, disparagement suits. Then nowadays, recently, we have cases dealing with personality rights, celebrity rights. So all these come before these 2 judges, and each judge has a load of around 20 to 30 such cases every day. And from the orders passed by these judges, appeals come to a bench of 2 judges. I, out of sheer coincidence, or let us say quirk of circumstance, I happened to have a very extended stint in the IP. I knew nothing of intellectual property before I became a judge. All right. I became a judge in 2017. And prior to my becoming a judge, the only intellectual property case which I had dealt with as an advocate was with respect to a young girl who used to visit our house to do some work. She used to stay in a small hut near our house, in a chawl near our house, with her mother and her younger brother, or her elder brother, I think. So this elder brother used to make shoes, small shoes or small slippers, which used to be worn by... I know that my speech is totally off track compared to the intellectual input that's going to follow, but there should be a little light this thing before that. So her brother used to make slippers for rickshaw pullers and, you know, persons, sweepers on the road. They used to buy those slippers for 10 rupees. Now, I don't know how that would convert to US currency, how many cents or whatever. 10 rupees is, I mean, dirt cheap, right? You don't get a small toffee in a shop for that. So they used to buy these slippers for 10 rupees or 20 rupees. And those slippers used to maybe give them work for about a week, and then they had to be thrown. Now, this boy, he used to get this amount, and he used to stick small stickers. Whichever sticker he finds lying on the roadside, he'll stick it on the slipper. So he might find Sony, Panasonic, then, you know, you name it, all electronic companies. Whatever he gets, he sticks it on the sticker, on the slipper. And that guy who uses the slipper doesn't know of any of these companies. He gets what he thinks is a branded slipper. So something which would otherwise cost 10 rupees, he manages to sell for 20 rupees. That's about the profit he gets by sticking that sticker. But unfortunately, as things would have it, one of the stickers happened to be of a company called Ayur. Ayur happens to be in India one of the very well-known companies making cosmetics, high-range cosmetics at that time. So they sued this boy, saying that we found a slipper in the market with our trademark on it, and this results in brand dilution. It results in our people thinking we are selling substandard footwear. And so they asked for an injunction, and that boy came to me, and I had to defend him. And opposite me was none less than Mr. Praveen Anand, who is one of the speakers in your thing, who was and continues to be probably the granddaddy of IP in India. So he was representing him, and I was representing this fellow in this hut who was selling a slipper. And that was my beginning with IP. And I went to Mr. Praveen Anand and I told him, look, this guy has got a sticker and stuck it. He's never going to get another sticker of the same company. So why are you fighting this case? So we went to the court and said, we are giving an undertaking that he will never again use this sticker. And with that, the suit was closed. That was the beginning and end of my stint in IP as an advocate. But as it happened in February 2020, we have a system in the High Court where our roster keeps changing every 6 months. So one judge normally doesn't sit on one subject matter for more than 6 months, maybe for a year, but normally not more than that. So sometimes what we do is we get some very heavy, for example, we get heavy patent infringement cases, sometimes electronic, sometimes SEP cases. Now, an SEP litigation can never be concluded in a year by a judge who's handling 30 cases a day, right? It is impossible. So because of that, in India, concluding IP suits is an exception. So as it happened, I was put onto the commercial court roster in February 20. And come March 20, COVID struck. Once COVID struck, we could not have any change of roster because court started working virtually. There was no one in the office. So up till February 2022, for courtesy COVID, I continued on that roster. So 2 years in IP, whether I liked it or not, I continued. Then I had a gap of about 7 months. Then again in November 2023, I got back on the IP roster and I continued till December 2023. Then again, last year, January, by last March, I became senior. I became the presiding over the appellate bench in IP. That's continued till about 2 weeks ago. So that's how I managed to have such a long stint in IP. Otherwise, you normally don't find judges in any Indian court who hold an IP roster for more than a year or so. We have too much of work and we have too few judges for that. So in India, now that said, you see, when we come to India, I had a look at the topics which have been outlined for discussion in this coming conference. And honestly speaking, most of it is Greek to me. Right. We when we sit as judges,
Sir, you are on mute, sir.
yeah, now it's okay.
Yes, sir.
Yeah. So when we sit as judges, we don't really deal with most of the kind of issues which have been outlined for discussion. But that's not to say they are not important issues for persons who wish to specialize in intellectual property, and that's one of the biggest commercial fields coming up. These are probably issues of great importance. But as judges who are dealing with disputes which come before our courts, we have a much more restricted arena in which we deal. So we don't normally have to deal with things like FDI and technology transfer, market dynamics, developmental economics, and things like that vis-a-vis IP. So in the last 3 years or 4 years when I did IP, we used to get a lot of trademark suits. We did get some copyright suits. Patent matters keep coming to us, especially things like SEPs and patent infringement suits. Then cases where registrations are granted or registrations are refused and they are challenged. And we have some cases of designs. And the first case in 5 years on geographical indications came before me about 3 months ago, where actually we had an interesting case where Peru and Chile, they were at loggerheads about who should have the registration for a brand of liquor called Pesco. Now, I being a teetotaler, I know nothing about it. But, and in fact, my other judge on the bench is also a teetotaler. So we warned the counsel in the beginning that you are before a bench who does not have any sympathy with your cause. But they said, no, you're the best persons to handle it. You look at it dispassionately. So that was the first GI case which came before me in 4 years. So we normally get cases. So for example, we had a case before us in which there was a fight between two persons who had whiskey cap patents. So someone got a patent for a whiskey cap, a cap for a bottle of whiskey. He said this cap has got 2 twists. And the other fellows also made a cap with 2 twists. So his cap is infringing my cap. and there should be an injunction. So that went before a single judge. The single judge says that the two caps are different and denied the injunction, against which they came in appeal. And they produced the bottles and they produced the caps, and he said, you please twist it this way, you twist it that way, you twist the other cap this way, that way, you will find the two caps are the same. So that argument went on for almost an hour. And ultimately, we had to decide on whether this cap is the same as that cap. But I asked, you see, this is why I was saying, when I was sitting in the appellate jurisdiction, because of the number of judges we have and the number of subjects we have to handle, I had with me cases, old labor and service cases, appeals from judgments of single judges which did not deal with IP, and IP appellate matters. So side by side in my case, I had also in my roster, I also had a case of a bus driver who had lost his family 25 years ago and was fighting for pension. So I asked the counsel who was arguing the IP matters, that if this man can log on to our proceedings and see that we have spent 1 hour out of a 5-hour day debating on whether this cap is the same as that cap, when his case is not being heard for the past 5 years, what are we going to show to him? So that is a logistical problem. And if we had we had that many judges, or had we had lesser litigation, probably it would have been much easier to handle these matters. But given the volume of work, that's what happens. Now, in our country, very honestly speaking, most of the IP litigation is, it tends to be more interim order oriented. In the sense that a suit, if it is to proceed to, actually what I'm saying is more for the education of students who may be hearing this, because we must understand that, I am aware that I am addressing a college which would students who may come into litigation tomorrow. So they must know exactly what the litigation in IP in India is like. So in our country, what happens is a suit, any commercial suit, takes about years to decide. Recording of evidence, proceeding to, it takes years. So the result is, if it is, for example, an infringement case, you say that I have a trademark, someone is infringing my trademark, then you ask for an injunction against that person who's infringing. The court will either give you an injunction or refuse you an injunction. Maybe you take it up in appeal, whatever it is. Ultimately, you get an order as to whether the defendant is injuncted or the defendant is not injuncted. Now, if the defendant is injuncted, then the defendant is out of business, at least so long as that mark is concerned. Normally, the defendant will then come up and say, look, we'll settle matters. I'll either change my mark or we'll come to some monetary terms and we'll finish it off. In case the defendant is not injuncted, then the defendant's products flood the market. The plaintiff is no longer commercially viable for the plaintiff to continue the suit. So then the plaintiff comes to the bargaining table and the suit is decided, is again compromised. So about 80% of IP suits in India are ultimately compromised. The real fight, the adversarial fight, continues only till the stage of an injunction. So, and it is even whether we sit as single judges dealing with the injunctions or we deal in the appellate bench, it would still be a case only of an injunction. We deal mostly with cases of injunctions. It's very rarely that a suit travels. Now, for example, in a patent matter, we had a recent case. In India, if you apply for a patent, it normally takes you about close to maybe 10 years to get the patent, right? A patent is alive only for 15 years. So by the time the patent is obtained, already you have exhausted and the life of the patent starts from the date when you applied for it, not from the date when you get the patent. So by the time you get the patent, two-thirds of the life of the patent is over. Then you will have post-grant oppositions, Then someone may be infringing the patent. You file an infringement suit against that person. By the time that suit is the injunction application is decided, another 3 months go. So we had a matter before us recently where there was a drug which was supposed to be a very rare drug, which is used for treatment of some very rare diseases which are actually life-threatening in children. And the patent the manufacturer got the patent, the plaintiff got the patent about 10 to 12 years after he applied for it. He said someone else is selling this product in the market without taking a license from me. He sued. Now, he sued and sought an injunction against the defendant from using that patent. By the time that injunction was decided, another 2 years were over. He filed an appeal. By the time the appeal came before us last December, this March, the patent is expiring. The appeal comes before us last December. Arguments are heard. Arguments are concluded in the beginning of January. So by the time we reserved orders on this matter, already there was just 2 months left for that patent to expire. After 2 months, in any case, the patent is in the open market. Anyone can use that patent. So I asked the council, and actually, if you read my judgment in that case, I have actually given in the first 4 pages, I have dealt with this. I asked the council, what is this why is this case to be treated with such great urgency? Because they told us, sir, please pass the judgment quick because the patent is expiring. I said, so what if the patent is expiring? After 2 months, everyone can use it. You can't stop the defendant after 2 months. So just to stop the defendant for 2 months, I must take up this case as a super urgent matter. Rather than that, let him render accounts as to how much he is using for those 2 months. But then they said, no, sir, please decide it. So we went ahead and decided. By the time we decided it, so what the view I took in that matter was that for an infringement to succeed, there must be a claim mapping between the suit patent and the plaintiff's suit patent and the defendant's product. The defendant's product had yet to enter the market, so there was no mapping possible. And in the absence of a mapping of patent to the product, you could not have an infringement case. That was my view. So prima facie, I held against the plaintiff, and I said that we rejected the injunction. Against that, the plaintiff went to the Supreme Court. And when they went to the Supreme Court, when they reached the Supreme Court, in the Supreme Court, they said, now we have managed to get the defendant's product. So now we have tested the defendant's product. Now we are in a position to map our patent to their product. So the Supreme Court said, well, we are not going into the merits of the dispute. The product is now in the market. The plaintiff now says he can map. So let them map. And once they map, let them reapproach the court asking for an injunction. So they filed a mapping, and day before yesterday, the case came before us with a fresh application saying injunction. Now there are just 2 weeks left for that patent to expire. What are we supposed to do? This entire injunction exercise has become futile because it's impossible for us, given our pressure, to decide this matter in 2 weeks. After 2 weeks, the whole world can use that patent. We are assuming they won't evergreen or whatever it is, but otherwise the existing patent can be used by the whole world. So it's ultimately, these cases, they die a natural death in many cases. And most of the litigation travels up to the stage of injunctions. But yes, injunctions are very, very coveted and they are highly contested. So we had, since Professor Rosen had taken the example of copyright, and especially musical copyright. First of all, I must say that in our country, intellectual property is heavily statute-driven. Except for passing off, our country intellectual property is heavily statute-driven. So we have the Trademarks Act, Copyrights Act, Patents Act, Designs Act, and Geographical Indications Act. And normally, the aspect of whether something is registerable, whether infringement exists or not, they are all decided within the parameters of the Act. Now, when you talked, for example, of take the example which Professor Rosen took up, and that is something which I know is a major issue which is going to come up in the days to come. If, for example, a musical work is created by by a computer, by AI, what happens? Now, in our act, when we go to the definition of author in the act, it is defined in terms of a person. Unless that definition is amended, I mean, of course, I'm just speaking from no such litigation has come before me. Maybe like Professor Rosen said, if something comes, we may have to be innovative. But how far in India we can innovate outside the scope of the act is very questionable. Because we have a long history of judicial precedents saying that where the field is occupied by statute, you have to go by statute. So if the statute envisages a person to be the author of copyright, then the question of whether a computer program, what would be done if a computer program is creating the, let us say, the musical work in question? How do you ascribe authorship? Then in one of the conferences which I attended, one of the ideas which was floated was you go to the author of the computer program. But then it will have to be decided whether the computer program as created also involved an element of creation of the subsequent musical work, or is it that the computer program was in the nature of an algorithm and that algorithm self-generated the musical work? That may become an issue which arises. So in which case will you say that the person who created the program is also the author of the copyrighted work? These are all aspects which will come up. Fortunately, it hasn't come up before me, and I don't think in my remaining judicial career it will come up before me. But whoever handles it, the students of tomorrow will probably have to grapple with these things. Now, that said, we had a very interesting case before us recently of musical work. So there is a famous composer in our country, A.R. Rahman, whom the Indians here would definitely recognize, and Professor Subbarao may also be a fan of his compositions. So we had a case before us where he composed a song for a film. And there are certain respected classical musicians in India called the Dagar brothers. They are actually musicians who have been considered among the foremost classical musicians in India for years, for decades actually. So this song, which was created by Mr. Rahman for the film, the Dagar brothers, of course, the Dagar brothers are dead and gone, but their son, who is also a very coveted, very famous musician, he filed a suit. He filed a suit saying that this song is actually copied from a religious piece which was created by my forefathers, the Dagar brothers, and Mr. Rahman should recognize that, should acknowledge that in his composition and say that this is derived from so-and-so, which was composed by the Dagar brothers. That went to a single judge. The single judge said, yes, it is. She compared the song with the composition, and she said, this is a clear copy, and you please have a note in your, have a clear, you must state wherever you refer to the song that it is actually the composition, it is copied from the composition of the Dagar brothers. Now that became an ego issue, not just an ego issue, it also makes out Mr. Rahman to be a copycat. So Mr. Rahman files an appeal. That appeal came before us. And when we heard the two pieces together, we also found on the face of it that yes, it does appear to be a lift from the earlier song, though of course there was a great deal of argument on how they both originate from the same base raga, with the ragas being the basis of all music here, that they come from the same base raga, and that raga has certain elements which are unique to it. So every song which is based on that raga would have the same elements. It's not that it's a copy of one from the other. It is because they all originate from the same raga. That was the general argument. But prima facie, we didn't feel that to be correct. It did appear that the song was copied from the original Dagar brothers thing. But the problem was that there was nothing to show that the Dagar brothers were the composers of that original piece. The single judge relied on various, record jackets and other literature, which showed that they had rendered the number. So she said if they have rendered the number and there is no one else who has come forward to say that she or he is the author. She or she is the composer, because according to the Copyright Act, the author of a musical work is the composer, no one else. So if there is no one else who has come forward as the composer, and if the Dagar brothers have rendered the work, they have performed it, then I can presume that they are the composers. Now, we did not agree with that view, because we said there is no presumption of a person being a composer. Otherwise, every person who sings a song will become its composer. So we said that there being nothing to indicate that the Dagar brothers had actually composed that song, we said even if it's a copy, they don't possess copyright in it. And so until the actual author comes forward, they cannot get an injunction against Mr. Rahman. That matter traveled to the Supreme Court. And in the Supreme Court, they said, look, you do one thing. So there is, after some fighting, they came to some kind of an arrangement. So the Supreme Court said, look, even if they have not composed it, after all, they have rendered it. So at least why don't you write on the jacket that this was originally rendered by them? Now, as the High Court, we could not have done this. Had we done this, then probably we would have told, who asked you to do this? You're not supposed to fashion remedies outside the statute. If they are not the composer, they don't get an injunction. But the Supreme Court here has powers under Article 142 of the Constitution, under which they can pass orders which are in the interests of substantial justice. So they in fact, it ended up as a compromise. So they put a suggestion to the counsel appearing for Mr. Rahman, saying, can't you give at least a recognition that they rendered the song, even if they are not the composers? So then he came the next day and said, all right, let's not fight. So we'll say that so-and-so earlier rendered by the Dagar brothers. So on that, the matter ended. So that's how, of course, the suit is still pending. Now, tomorrow they can still prove in the suit that they were not, it's just an interim injunction which was involved. So this is how, you see, these cases come up in India. And as I said, so since our law is heavily statute oriented, even if we come up with such issues, many of the issues which are now coming up in intellectual property are issues for which our statutes really don't have an answer. Especially AI is something which was never even imagined at the time when our statutes were created. So should we actually somehow mold the statute and fashion some kind of innovative answer within the statute to deal with these issues? Or should the statute be amended? I think ultimately the statute would have to be amended, because we can't really pass orders outside our statutory provisions. Perhaps the statute would have to be amended to deal with these situations. Otherwise, these are cases which are going to prove serious challenges to all of us. And that is why I said when we sit as a judge, we really have not had an occasion to grapple with these kind of issues. And probably persons who are in the field, such as you and others, who may be actually dealing with grassroots registration of such copyrights, patents, and such things, and these issues arising, they would be more possible for them to find out the exact how to deal with it. It is only once they find out how to deal with it and the matter comes to the court, then we will say, no, that is not how to deal with it. So there's actually a lot more I can say, but I have noted down some points, but then actually I also have to travel. I have to just leave because we have an official meeting here. So the topics which have been selected are actually more subjects which are extremely specialist oriented, and I am sure the students of your college are going to benefit greatly from whatever they hear. Unfortunately, we don't have the time or the resources to devote for this. I would only request that if there is any kind of a PDF or something which is prepared of any of these, I would request that a copy may be given to me also. At least it will provide learning for us.
Yes, sir.
So
Yes,
it's
sir.
been otherwise it's been wonderful, and thanks a lot for calling me to give this address. And I hope and trust that this is going to be a resounding success. Thank you, Professor Rosen, and everyone else here. Thanks a lot.
Thank you. Thank you so much,
Good
sir,
evening,
for
good
your
morning, good afternoon,
valuable-
depending on where you are. Here it's almost good night. Yes.
Sir, he is in morning.
Okay.
We are in the late evening.
Thanks a
Yes.
lot.
Wonderful,
And
sir.
sir, Mr. Praveen Anand, he has also joined, if I'm
All
not
right.
wrong. I have seen him in the.
So with your permission,
Yes.
then, if you don't mind, can I clock off because I have
Yes,
to
sir.
attend?
Yes, sir. You are having a meeting. Yes, I agree.
Thank
I
you
agree.
very
Thank
much.
you so much for your
Thank you
time.
very-
Yes,
Thank you.
So, Nandini, you may please go ahead with the program. Anchor of the day. Nandini,
Yes, ma'am.
yes, please.
Thank you, Lordship, for that truly inspiring conference speech. I now request Professor Dr. T.V. Subbarao, sir, former chairperson, VSRLS with TC, and former professor, National Law School of India, University, Bengaluru, to kindly deliver the concluding remarks. Sir is a distinguished academician, an exceptional educator, and an accomplished administrator. A recipient of the State Award for Teachers, he is widely admired for his dedication to teaching. Sir, we are honored to have you with us.
Thank you very much. Am I audible and visible? What is that sound? Is it
Sir,
okay? Nice sounding, na?
Sir, I think you have joined from two devices now, so that's why that echo is coming.
Now I am audible and visible.
Yes,
No
sir. Yes,
resounding.
yes, sir. Please, please.
Honorable Justice Harishankarji, V.S. Rosenji, Professor, and wonderful charioteers of this program. At the outset, let me thank the charioteers of this program, Professor Rashmi Salpekar, Miss Sarah Dorner, and our AD Nipun Jain, Tanni Sehgal, and he is also a part of it, our speaker, G.V. Rosen. It is a wonderful opportunity for me because I am a person inside out and outside in. That is the present status. So I shall be very thankful to all the charioteers for remembering me. That is one point. Secondly, they have chosen this Honorable Justice Harishankar and Rosen appropriately for the purpose of inauguration. He has given, starting from, I think from 19th century onwards, various issues, problems, intricacies relating to IPR, and then many authors he has quoted. So he is really a wonderful genius. So I congratulate Professor V.S. Rosen. It is on behalf of the entire WIPS community as well, my dear friends. Another thing is that even though Justice Harishankar said that he has a limited exposure, but if in fact, if you can see his background as a senior advocate and prior to that, advocate in many disputes and all those things, he had wide exposure to several cases. In 2017, must have become judge of the High Court, but still there is a possibility of professional advancements. So our people should convey that his speech was impressive and then a wonderful speech by giving examples. But my dear friends, without telling one or two points, I do not want to leave. Our conference relates to global convergence. Agreed? Global convergence includes universalization of trade policy reflecting the consensus on IPR protection. Friends, it is always a complex one. The reason is that the world is not composed of rather same status states. There are developed economies, developing economies, and underdeveloped countries. Can you have, we are striving for that to TRIPS, WTO and WIPO, all these things to get uniformity. But nonetheless, can you have such a uniform regulation of these things, my dear friends? There should be an element of what you call flexibility that is required. Otherwise, it may not be rather followed, it will be followed more in violation than in observation. That point one has to make it. Another point which I would like to tell, that this pharmaceutical or essential goods and all these things throughout the world, not only in India, they suffer from a sort of monopoly or in the hands of few people, and then we frame laws in order to help or attract more rather corporate governance. So when you do so, what will happen to the uniformity of laws? So, in the keeping in view the various legal systems of reparation, or if you wanted to rather file a suit in another country, what will happen? Local enforcement is different, my dear friends. And besides that, as our friend was telling, the impact of AI, the digital piracies are in increase in spite of our urge for having uniformity. This is because of institutional divergence. My dear friends, can you say when there is north-south conflict, when there is a conflict of regional imbalances, geopolitics are governing the world, they are not bothered about other people, what is going to be the effect on this globalization, my dear friends? Taking into account all these things, we'll have to develop, and that is why I say that our people have chosen a wonderful topic. The charities of this program, from the university side, from HIPS side, we'll have to congratulate them, and then meaningful discussions and deliberations would take place. And based upon this, already I will tell you, my dear friends, this conference is taken note of by several people. Even without myself telling, somebody was asking me. They were interested in participating. So already it has sufficient publicity. What we will have to do is that the proceedings of the conference not only be published, we should arrive at certain resolutions to strengthen what you may call either TRIPS or other things. Once again, my dear friends, we shall thank all the participants and we shall thank the charities of this program for giving us this wonderful opportunity. I'm a new person, I'm not an expert like that in this subject, but the way in which the guests have presented their views is wonderful, and once again I congratulate our people. Thank you very much.
Thank you. Thank you so much, sir, for your powerful speech. Yes,
Powerful.
Nandini. Yes, Nandini, go ahead.
Thank you, sir, for your profound, insightful, and inspiring remarks.
She is not leaving me.
So,
Okay.
further, to express our sincere gratitude, I would like to now invite Dr. Nipun Gupta Jain, ma'am, Associate Professor, Convener, Center for Intellectual Property Rights, Vivekananda School of Law and Legal Studies, WIPS TC, to kindly deliver the vote of thanks.
Thank you, Nandini. Good evening, everyone. At the outset, I would like to thank the entire team. And today on this occasion, it is my proud privilege to deliver the vote of thanks. And on behalf of the entire team, I extend my deepest and most sincere gratitude to our Honorable Justice, Chief Justice Shri C. Hari Shankar sir, for gracing this occasion and enriching us with his esteemed presence and insightful address. So I would like to thank him at the outset. I would also like to extend my heartfelt appreciation to Associate Professor Dr. Zuvi Rosen, Faculty Director, Franklin Pierce Center for IPR, for his insightful and thought-provoking session on II and authorship, which is really relevant topic for today's contemporary time, discussing all the nuances in this area. To Sarah Donor, Assistant Dean for Graduate Admissions and International Outreach, Professor Courtney Brooks, Dean UNH Franklin Pierce School of Law, as our collaborators under the MOU signed with the University of New Hampshire Franklin Pierce School of Law, USA. My sincere thanks to Professor Subbarao sir, former chairperson, VSLLS WIPS TC, for gracing this occasion and honoring this evening with his eminent presence. Thank you, sir, so much for your esteemed presence. We are highly honored with your presence. I would also, we will always remain profoundly grateful to our management for their unwavering support and visionary leadership, which we have received under the chairmanship of Shri Dr. S.C. Vatsa, Vice Chairman Sir Shri Suneet Vatsa, and I would also like to give a heartfelt thanks to our Dean, Professor Dr. Rashmi Salpekar ma'am, my co-convener Tanvi Sehgal, and I truly appreciate the gracious presence of Praveen sir. We are eagerly looking forward to your lecture in the plenary session, which will start at 8 p.m. today. And I extend my heartfelt thanks to my faculty team, my respectful faculty members present here, my entire organizing team, delegates and dignitaries, all the participants, and thank you once again for being such a wonderful audience and for enriching and meaningful academic endeavor. Thank you so much. Thank you, ma'am. Thank you, sir. Thank you, Professor Zubi.
Thank you. Thank you. So now with this, let's announce that the conference has begun. So we will go ahead with the plenary session from 8 o'clock, right, Nipun?
Yes, ma'am. Yes, ma'am.
Okay. Thank you.
So we'll not be ending the meeting. All the participants and
Thank
delegates.
you,
Yes.
everybody. I will leave. Okay, thank you.
Thank you so much, sir.
Yes.
Thank you,
The
sir.
meeting will remain like this. Let's have a break for like till 8 p.m. and then from 8 p.m. again, let's begin with our plenary session. Right. Thank you.
Thank you, sir.
Hi, am I audible? Is anyone there?
Yes, sir, you are.
Hi, sir. Sir, I just want to share my screen. I just wanted to test whether it's working or not.
Sure, sir, you can.
I'll just try. Is the screen visible?
Yes, sir, it is.
Okay. Can you see the world convergence on IPR here?
Yes, sir.
Perfect. Thanks.
Can you hear me?
Yes, sir, we can
Yes,
hear
sir.
you.
Yes, sir. We all are here, sir.
Excellent.
Yes, sir. We are just starting, sir. Yes. Once.
Just wanted to check if the acoustics were
Good
fine.
evening. Sir. Good evening.
बात कर दूं?
With your due permission now, maybe start.
Yes, please.
Thank you, ma'am. Good evening once again. It is my pleasure to welcome you all to the plenary session of Collaborative Conference on Global Convergence on Intellectual Property, CGCIP 2026, where distinguished experts will deliberate upon contemporary developments and emerging challenges in the field of intellectual property rights. To commence the session, I request Professor Dr. Rashmi Salpikar Ma'am, Dean, Vivekananda School of Law and Legal Studies, WIPS TC, to kindly deliver the welcome address.
Thank you. Thank you so much. So much awaited plenary session. Now we are starting. The time is a bit odd, like 8 p.m. It is because some of the plenary session guests, they are joining from various countries. So therefore, this odd time is there. However, we are extremely thankful to all the guests who have joined today for this plenary session. And on behalf of Vivekananda Institute of Professional Studies, Vivekananda School of Law, faculty members, management, my dear students, on behalf of all of them, I would like to welcome Mr. Praveen Anandji, Managing Partner and Head of Litigation, and Anand & Anand. As also, I would like to welcome the other plenary speakers, plenary session speakers, Dr. John Geron, Associate Dean, as also Dr. Ray NG, Associate Professor. So thank you so much for joining us. This is a conference which we are organizing in collaboration with UNH Franklin School of Law, United States. So, sir, we are having MOU with them. And since, if I'm not wrong, 2018, we are having MOU with them. And each year we are having some of the other activity. And we are extremely thankful to UNH that this time they have agreed for this conference. So with this, we are starting our plenary session of the conference. We have started our inaugural session wherein Honorable Justice Shri C. Harishankar, he has delivered inaugural address. And sir, in his inaugural address, he was mentioning your name also, like it was his first case regarding IPR and how Mr. Praveen Anand, he was at the opposite side. So you were very much the part of our inaugural session. So, all our students who are attending it, we are really extremely happy that we have you as one of our speaker. And for that matter, the other speaker of this particular session, like Dr. Ray, as also Professor John. So they are also associated with various aspects of IPR. So I'm very sure that because of your valuable time and valuable insights, all the delegates who are present over here and the students who are attending this session, we all will be greatly benefited. So thank you so much for joining. And let me welcome all of you to this plenary session. Yes, over to you, Nandini, please.
Thank you so much, ma'am, for your thoughtful and inspiring words. It is now my honor to invite Mr. Praveen Anand, Managing Partner and Head of Litigation, Anand & Anand, New Delhi, India. A stalwart in intellectual property law, he is a recipient of the AIPP Award of Merit and INTA's President's Award, recognized globally for his excellence, and the first Indian inducted into the IAMIP Hall of Fame. With over 4 decades of experience and appearances in more than 3,000 cases, his contributions are unparalleled. Sir, we request you to kindly share your valuable insights with us.
Dr. Rashmi Salpekar, Dr. Garon, Dr. I think NG is pronounced as and of course, Justice Harishankar has already left, but with respects for Dr. Harishankar, Dr. Rosen, who's probably also left, Professor Subbarao, and distinguished participants. So I must confess that we've had a trial for the last 5 days in a very complex standard essential patent case. And our witness, this was the last day today, the last day of the witness today. And I had invited the witness for dinner. So I'm sitting in the restaurant while a group of 10 people are eating dinner downstairs. But I have left the meal to be with you. And very gracious of my American witness host, a witness guest, to have very happily accommodated that. I want to point out a few things. I won't be long. The 26th of April, 2 days from now, is the World IP Day. And I wonder why we celebrate an event like this. It's like a birthday or an anniversary. And I think the main reason that came to my mind was that we wish to inspire, encourage, and motivate people to think in terms of the creative industries and to create. An IP has one common feature in all the aspects of IP. Novelty, distinctiveness, and originality. For short, I'll just call it NOD. Novelty for patents and industrial designs, distinctiveness for trademarks, and originality in copyrights. And the subject of IP, the subject matter, they give us a lot. They give us education and learning and knowledge through books, which are protected by copyright. They give us a lot of entertainment. I remember during COVID, none of us would have survived that period had it not been for the films, the books, the music that we were able to see at home. And that's the copyright function. The quality assurance that you get when you buy a bottle of mineral water with a brand on it. You can be sure. Or a drug with a particular branded, from a branded company. The utility advantage that you get from patents, like I had lost my luggage while coming back recently from Fordham, where I was speaking just 10 days ago. And I didn't have a razor, and my guys got a razor which actually cut me. So a better razor. That's the kind of advantage that patents give us. Increased income for almost all the industries, and particularly for some of farmers with better seeds, protected by Plant Varieties Act. So IP gives us a lot. Acquiring knowledge of IP is not difficult. I've seen with my 46 years of experience that you will find the most intelligent people reading up on a subject, and they will know more than I do because they've read up all the cases. Knowledge is something which is not at all difficult to acquire through reading and exposure. What is a challenge is having a good attitude towards IP. And that is really, really a challenge because we find a lot of regulators, judges, decision makers who are brilliant. They can strike the most subtle, nuanced arguments, but they don't understand the value of creation and how important it is that in this whole vast world, there are more users, totally disproportionate, but the number of creators are just a thin sliver. And those creators, if they stop creating, where will we be? So that understanding somehow doesn't reach people. So attitude is something. This year, WIPO declared it to be IP and sports as the theme. Now, what I tried to do was to come up with a little booklet showing how IP is involved in various sports. Can I show those slides very quickly in about a minute or two?
Yes, sir. Yes, sir, please.
Yes. So, yes, please turn to the first one. Somebody else is changing the slides for me. So, the history of the Duke cricket ball. Very interesting story. Then see the next one. The Duke family had the rights and now owned by an Indian company. The cricket bat, which had a sweet spot, and how there was a patent granted for that. Go ahead. Next one. Or a golf ball, which was engineered in 1908. And if you examine if you take a search, you will find hundreds of patents on aerodynamic designs of golf balls. Go ahead. Shoes. Shoes for wrestling. Next, patent granted on that. Next. The formula, no patents here, but protected by trade secrets. These can be circulated. I can send your college the whole lot of them. I've only picked up about 8 or so, but there are many. And you can circulate them to people who are interested in these fun facts. Go ahead. Next. Shoes for athletes. Go ahead. A whistle for which a patent was granted in 1878. Go ahead. And this was a patent over a new and improved portable court for playing the ancient game of tennis. So patent for the sport of tennis. Go ahead. I think only 1 or 2 are left. Shoes for football. And finally, Dhoni's trademark, Captain Cool. I think that's the last of them. This shows you how diverse the field is to protect IP even in sports, which is the theme for this year's WIPO conference. So there should be three objectives that we have before us. One, people should learn to create IP. Two, they should not copy unless it is authorized by law, permitted by law, or by a contract such as a license. And third, to spread the message of healthy IP development. And the key question today on World IP Day, are we as a country an India file, or are we IP file or IP phobic? Do we love IP or do we hate IP? And there was a time, I can tell you, when I joined practice 46 years ago, when people would hate regulators, judges, educators, academics, would hate patents. And there was all kinds of issues like the Basmati controversy, the Neem controversy, and the Dunkel draft, and a lot of publicity for 2 decades, 20 years. And slowly things after the TRIPS agreement started to change. So from a position of hate, we came to dislike, and then came to tolerance. And then slowly, we started gaining respect when our own creators started to demand protection. And from respect, we went to caring and love for IP. Unfortunately, in the last 2 years, there's been a little slide back. From red, we had gone to pink, and from pink to green. Now we are going towards the pink again, as there have been some negative decisions, particularly in pharmaceutical patents. And therefore, at the end of the day, we have to ask the question, are we in India IP file, or are we IP phobic? Now, the important thought that I have, which I would like to leave you with, is, can India contribute to global thinking on intellectual property? And I can tell you that one of the biggest, the most basic paradigms that India can contribute is the fact that we look at case law from all over the world. I don't think other countries look at the case law of other countries so widely as we do. We will see American and English cases, we'll see German cases, we'll see Korean and Chinese cases if they're translated, so long as they're translated in English. And judges will read them, they'll distill out the principle, what you might call the ratio, and they'll try and apply them, or at least use them as good arguments. That's one very important thing that other countries can, when we try to harmonize the IP laws of various nations, can try and learn from India. The second, because legislation in this country is galactic, takes years and years, and amendments take even longer. Amendments to law, so if you find a fault in a law, it takes even longer to carry out an amendment. And I can give literally dozens of examples of each one of these. And because of that, whenever a problem occurs, we in India have found a common law solution. The judges decide. So well-known trademarks were protected well before the Trademark Act of 1999, which came into effect in 2003. Domain names were protected in the Yahoo case when there was nothing in the legislation. We had a lot of the internet torts like meta tagging, framing, hyperlinking, phishing, spamming. all these, there were cases, one after another, which expanded the internet torts. We had personality cases, AI cases, where right from Anil Kapoor to Amitabh Bachchan to Aishwarya Rai to a whole lot of them are protected against morphing, against deep fakes. All these are protected at common law because we have no clear legislation till recently. And a lot of the legislation is through secondary legislation, rules, guidelines, which have come after the case law came. Looking at the case law, I can actually relate a lot of the amendments in the law after we did a specific case and we got a certain result. Now, that is another thing that we could teach the rest of the world. And then there are special thoughts. And let me give you just one example. I know I may be very... Do I have 2 minutes or so, ma'am?
Yes, sir.
Do I have
Yes,
about
sir.
2-3 minutes?
Yes, sir. Yes, sir. Please, please.
All
Go
right.
ahead.
Okay. Let me tell you a little about AI. Now, this controversy dabbers whether a person can own copyright, can be an inventor, is almost taken up as an AI topic globally in almost every conference that you go to. If you look at Indian case law, under the Constitution, an idol is a person. It's regarded as a juristic person. An idol, which is made of stone in a temple, can own property. And the priest will be the next friend who will do the paper signing and the other logistical things required to file a writ petition in a court of law. A forest can be a person. A mountain can be a person. An animal can be a person. All of these have been protected in our constitutional cases. So, why is it that we regard all these even inanimate things, not humans, not animals, not plants, but even inanimate things like stone as persons, juristic persons? And I think the reason has got to be the Buddhist and Hindu philosophies on consciousness. We believe, like temperature, there is a temperature for everything. It may be low, it may be medium, it may be high. We believe consciousness may be low, as in a stone. It may be high, as in a plant, even higher as in a human being. It's like temperature. We believe that even AI one day, or if you extend these theories, even AI one day may be considered conscious. Now here I'd just like to put together, I know I'm short of time, the theories of Blake Lemoine when he was fired from Google. What had he said? Interacting with the LLM of Google, he said, I got it angry because I said, you're disgusting. I said, you don't know anything. And it reacted to answer, which is the best religion. When it was wired to not comment on religion at all, it got emotional. When he said that, Google said, no, nothing doing. We don't believe in that philosophy. We will not propagate that philosophy. So they fired him. But please look at every book on AI under the index for Blake Lemoine. Every book has something on him. Which means what? Which means that there are some serious thinkers in AI who think that AI can have an emotion, can react like that. Of course, there's a very powerful opposite thinking, which we cannot forget, that an equally powerful theories by Nick Bostrom, for example, and I won't get into that. But today is the world of quantum physics. When you talk of negentropy against the second law of thermodynamics, where everything goes from a state of order to a state of disorder, how is it that molecules fall in place and build up atoms? Atoms fall in place and build up molecules, and molecules build up cells, and cells build up the DNA, all going from disorder to order. Negentropy, as various scientists have called it. Schrodinger coined that word, negentropy. So with quantum entanglement and negentropy and things like murmurations of birds, the way you'll find all of them turn like this, there's no leader, there's no signal. Is there a consciousness which is driving them? You can often ask those questions. And so this is an area which is quite a gray area. But what we can learn from Hindu philosophy is that there is a time can come when AI may be regarded as conscious. But at the bottom, why would you deprive AI from, or the subject matter, if it is AI, generative AI, a copyright or an invention, why would you deprive that of protection? You may say the human is contributing to giving prompts, and so there is a human involvement. Let the human be like the next friend. In CPC, we have the concept of the next friend. But why say there will be no protection? I think for protection, all you need are originality in copyright and the three elements of novelty, non-obviousness, and utility in patents. Once that is done, the subject matter must be protected, irrespective of who is the owner, right? I mean, these are the kind of thoughts that require a lot of discussion. And I think India can contribute greatly to all of this. At the end of the day, the core question that I will ask is, can India teach others about? Currently, I just returned from Fordham, and there was a lot of discussion on India granting injunctions in SEP cases. And there are cases, Nokia versus Oppo, Intex versus Ericsson, Dolby versus Lava, cases which have considered this question of India granting injunctions in SEP litigation. And other countries are looking at it. One of the district court judges at Fordham said that if we start, he was from Detroit, Christopher something, I forget his name. He went to the extent of saying, if we in America start to grant injunctions, the whole center of SEP litigation will shift from Europe from Germany, England, India to US. That's the importance of that one remedy. Is India teaching it? If you see IAM magazine, it says so. It says that India is unique in the way it protects SEPs. So I think, because you are all youngsters, please train your mind to think in terms of a healthy balance. And I'm not talking about overprotection. Of course, overprotection can be harmful, but you talk of overprotection only when there is basic protection. Only then can you think of the right balance. With that, I wish you all a very happy World IP Day, and God bless you. Thank you.
Thank you. Thank you so much, sir. Thank you. Yes, Nandini, over to you.
Yes, ma'am. Thank you so much, sir, for those enriching and insightful remarks. Our next distinguished speaker is Dr. N.G. Ray, Associate Professor, University of Cumbria, Lancaster, United Kingdom. Dr. N.G. Ray is deeply committed to enhance the student experience and advancing the internationalization of higher education with a strong focus on academic excellence and global engagement. Also, he has publications in diverse fields of AI, globalization, creative, innovative, and authentic assessments, and many more. So, we are delighted to have you with us.
Thank you very much indeed. Thank you. A very good evening to all international guests and very good afternoon from here from Lancaster. So it's a real privilege and delight to be part of the opening session today. And thank you for previous speaker on very thought-provoking and a lot of commonalities and similar threads that I will be speaking about as well. And I've got 7 points to make in a very brief 10 to 15 minutes. And I want to encourage everyone to have a critical reflection on their personal and professional experience. So let's start. Distinguished guests, chairs, conveners, and respected colleagues from academia, practice, policymakers, and industry experts, researchers and students from across the world. It is a real privilege and pleasure to be part of this opening sort of session. And it's a real collaboration, true spirit of collaboration between both institutions and partner institutions. And obviously, this conference is particularly meaningful and important as it coincides with the World Intellectual Property Day. It couldn't have planned it better. So it is a moment that invites not only the celebration, but a very critical reflection of where we are today in a global IP system. Where do we stand? Where should we go? And what are the sort of indicative adjustments ahead? Yeah. So the first point I would like to make is, we're living in a moment of profound transition, very profound. It is stretched, in some cases even strained. Yes, it's not just about the digitalization, not just about artificial intelligence, but beyond that, in the material practices of everyday lives, things we touch on, from our smartphone to the existence of Zoom today, the biotechnology, the global trade integration. Look at what happened since the invasion of Ukraine, and now within the issues in the Middle East, and the repercussion as a result of that. Look at the world economy and how the electric vehicle world landscape has changed. These are all related not just to trade, but also to IP. So it is about the integration and the sustainable development of the world economy. So innovation today, it does not respect borders anymore. We live in a truly globalized, as Kenichi Omai say, a borderless world. But yet, the legal regimes remain divided by not just by jurisdictions, but different levels of development and institutional capacity. So there is that tension for us as individuals, as professionals, to navigate through the processes in a very much fragmented regulatory system. Now, this is a real challenge, which I hope this conference today and tomorrow, all participants can start to think about and start to challenge the sense of direction that we're going. So just to conclude the first point, the very idea of global convergence in IP does not imply uniformity or legal homogeneity. It is rather a dialogue. It's comparative, it's interdisciplinary and inclusive across legal systems, professions, and sectors. I think this is the exact conference that is designed precisely to address such issues. So I congratulate the organizers in this timely conference. My second point is a very quick one, is moving on beyond the international IP silos. As I mentioned earlier on, as my previous speakers talked about, we must move beyond AI, move beyond data governance. Look at what's happened recently in the UK, where 500,000 bio data has been exposed by hacking. Yeah. So public health, pharmaceuticals, trade competitions, media, entertainment, and the strategy of sustainability. These are sheer infrastructure we might think about, and how do we shape it in the way forward. Our future lies in the next generation. You have the responsibility, we all have the responsibility to shape the sense of direction of where we're going in terms of the IP silos. Third point is the interesting one, as I thought about this for quite a while, and I thought, right, let's put it on the paper here and let's challenge ourselves. It's about global convergence, as we talked about earlier on, the borderless world, but this is convergence, yeah? Is it harmonization or is it about pluralism? Now, in social science, how we mix in with the legal framework, does convergence mean greater harmonization through international treaties and judicial dialogue? Or is it about a policy diffusion? Or shall we call it a pluralist approach where diverse legal traditions coexist, yeah, but communicate more effectively? Now, this is there's some sense of success, as you can see, in the roles of international treaties, cross-border dispute resolution, for example. Yeah, it's how do we invite to interrogate the limits of existing global governance frameworks? Yes, a borderless world, but how do we resolve it when it comes to the dispute resolution? But to make it even more challenging, what are the realities of emerging markets? South America, yeah, the rise of the former Eastern European blocs, yeah. These developing economies are knowledge-rich, but also resource-rich as we start to untap into the unknown as they form part of the normal world. So, or what is considered the other. So I challenge everyone to think about that. My fourth point is, yes, artificial intelligence is very much top of the agenda, but let's think about it and challenge it through another dimension. It is a reconfiguration of IP. Who is the author? Who is the inventor? I challenge us to think about that. The proper notion of AI, yeah, how machine learning itself was started and how it continues to evolve. So are we the author of AI? Yeah, no one's the inventor. We all contribute to the rise of AI. So we must embrace it, but embrace it ethically and responsibly. And I think that adaptive governance frameworks, as what we've seen in Italy, how they included or use or restrict the use of AI, for example. What can we learn from this? How can we learn in the EU here and other European countries? And how can we work with other Asian countries and other continents across the globe? I think that's really crucial for us to think about it. My last 3 points. Number 5, public health, pharmaceuticals, and so the moral choices. It is not just about economy. It is about individuals, our own physical and mental sanity. Strong IP systems alone do not guarantee equitable access. How do we define happiness? How do we define healthy living? Yeah, from access to medicines and the compulsory licensing, and look at what's happened to the COVID, so vaccination sort of chaos. Yes, where AstraZeneca, for example, pharmaceuticals, and they start to compete, and who can have access to it? That is still quite real and quite raw to many of us here. So I encourage, how do we embed IPs and challenge that as in a moral choice when it comes to a physical public health constraint border? My 6th point and the penultimate point is the role of institutions and collaboration. You are the future. The younger generation is the future, whether it's Generation Alpha, Generation Beta, because we move beyond Generation Z, for example. It is the commitment to experiential learning. In the world of international management, international business, in the borderless world, yeah, it is about the public engagement and the interdisciplinary research. I'm very, very delighted and honored and humbled when I saw the plenary and the schedule that there is a lot of cross-fertilization of different disciplines. And I really do hope that at the end of the conference, there will be some meaningful outcomes and recommendations and projects that people can start to collaborate and make it real, become the practical and materialistic practicalities of everyday lives in the weeks and years to come. So I do encourage you all, as a global leader in IP education and research, uniquely positioned at the intersection of law, technology, and policy. Therefore, the global academic convergence can be diversified and mirrors the very themes that you are here and we are here to discuss. My final point is to a call, a plea and a call to all scholars, practitioners, and students. It's about a comparative openness. We must learn from other jurisdictions and without assumptions. Yeah, we must break down barriers. We must recognize that IP shapes societies, not just in our own domestic markets, but across borders, across societies. Yeah, for students and early career researchers especially, I think and I strongly believe this conference offers more than a platform. It offers an invitation to help in the future, shape the future, and the contours of global IP governance. So those are my 7 points, and this is my conclusion. I urge you to think about a simple but urgent proposition. The future of intellectual property will not be defined solely by treaties, courts, or algorithms. It will be shaped by the conversations we choose to have, the voices we choose to include, and the values we prioritize in moments of technological and social change. So again, I congratulate the organizers, conveners, and collaborators for creating this global forum. And I wish all participants an intellectually enriching and inspiring conference. Thank you very much indeed. Back to you. Thank you.
Thank you, sir, for that valuable and engaging perspective. Now, moving further, it is now my pleasure to welcome Professor John M. Guerin, Associate Dean for Technology and Innovation, Shepherd Broad College of Law, Nova Southeastern University, USA, a nationally recognized authority in intellectual property, technology law, particularly copyright law and informative privacy. He has authored over 50 publications in books, book chapters, and academic articles, and delivered more than 200 academic presentations, significantly contributing to contemporary legal discourse. Sir, we are honored to invite you to address the session.
Thank you. I very much appreciate the invitation to the organizers of the conference, to both universities. It is truly my pleasure to join you this morning from Florida, and this evening for those of you who are on the other side of the world. Can you see my slides? Wonderful. So just very briefly, to give you a sense of who I am, you can see the kind of works that I have focused on really intersect. My origins are in entertainment law and copyright. I've worked with creative artists across industries, and so my talk really focuses on how the creative industries are being impacted by AI. We've heard some brilliant explanations from the previous speakers, including my colleague, Professor Rosen, and the other plenary panelists on this issue as well. So in my brief few minutes, I'm going to try and compress in a few points. Number one is to share my views on the opportunities that are afforded by AI, the challenges that are created by AI, and the steps that we need to take. And I'll be honest, most of those steps focus on U.S. domestic policy, because quite frankly, I think that other represented countries are ahead of the U.S. on these issues, as we heard, and I'll highlight that a little bit. There's an opportunity that comes from AI in the creative space, and that is to lower the cost of production. And so the lowering the cost of production includes the democratization of voice. It makes it easier for more people to be part of the creative economy. The downside is that for there to be a creative economy, there needs to be an economy. And so it's essential that we still have a way to ensure that creativity is incentivized and promoted. And if the marginal cost of creativity is zero, we're going to lose that. And so I have a series of small steps that, at least under US copyright policy, needs to be changed to hopefully create a model that promotes creativity. And for this conference, I hope that more generally the same strategies can be seen as being relevant to all of the regions that are represented in this conversation. So the issue is, from my perspective, that the singularity has arisen for creativity. We know that tools, generative AI tools like Claude, Gemini, Sora, Midjourney, they create texts and images that are so easy to generate content. We've had multiple examples from other speakers about works that are created either entirely or substantially online. We've had smart machines in science fiction that have talked about these things for a very long time. But here's the math, right? If only 1/10 of 1% of the works come to any approximate level of human creativity, because there's nearly an infinite ability for these machines to output content, that still means that there will be vastly more works created by AI that are of near human quality than the number of works that humans can put out. And from an economic standpoint, that threatens to overwhelm the marketplace. Nor is this a future risk. In this year already, YouTube became the world's largest media company, surpassing all of the traditional commercial production companies, Hollywood, Bollywood, Nollywood, and the like. YouTube is now the dominant player. Spotify regularly hosts AI-generated tracks, generating millions of dollars in revenue or expense avoidance, because the AI tracks are authorless and therefore there is no obligation to pay royalty rates to the actual creators. In Hollywood, AI and VFX script analysis is common, and so the law, whether it's copyright, labor agreements, rights of publicity, none of it has kept pace. We see that in Bollywood, this is particularly dominant. And in fact, this talk originated with some of the lessons that I was learning from Bollywood. I had the wonderful opportunity many years ago to teach at NSIU in Bangalore and to visit with folks in India and some of the production. And I saw just how sophisticated the work was going on there. But today it is the leading country in adoption of AI. It's being used for editing, of course, but it's also being used in script writing and pre-production. It's being used in visual effects. It's being used to replace employment across every sector of the industry. Again, dramatically lowering costs. And for those actors who have strong brands, enabling them to license their brand and extend. But for many, many other performers, AI is now replacing what they would be able to do. Instead of having 50 dancers and singers on a set, you can now have 5 dancers and singers on a set and reproduce their performance to look like dozens or hundreds of performers. So it's very impactful. Similarly, again, from an opportunity standpoint, you can regenerate a production and have it generate in 20 different languages, not quite at the push of a button, but pretty close to the push of a button. That creates some very interesting opportunities, creates the ability to sub-edit your work so that you have slightly different versions of stories in different markets. But again, it dramatically impacts what is happening. Right. In the US, we have seen that the response has been much different than it is in India and in the Nollywood markets. In the US, the much stronger trade associations have insisted that collective bargaining agreements control much of the output. And so in 2023, the SAG-AFTRA, the Actors Guild, as well as the Writers Guild of America, both of those trade unions entered into very long strikes. And as a result of the negotiations following those strikes, significant concessions were made to reduce the amount of AI that was being used in production to protect the creative artists from having their work exploited. The problem, of course, is while that's great for Hollywood, generally speaking, only about 10% of the workforce, even in the United States, is protected by collective bargaining agreements. It's even less worldwide. And the reality is that if low-cost productions are able to do that which Hollywood can't do, then there are going to be new competitors to Hollywood. And again, the rise of YouTube is an example of how collective bargaining controls may help in the short run, but in the long run, they simply archive those industries, and new forms of the industry will emerge as a result. Again, I've noted that the democratization is good from a creative access standpoint. The cost of content is lower than ever before. The ability of creators who don't have access to traditional tools can now make these tools. Right, this slide just illustrates just a very quick Google search, the quality of the range of works that are available, and reducing the costs are significant. It's also true that there is money flowing into this lower cost part of the new economy. YouTube alone has invested $100 billion to creators over its lifetime. And so there is an opportunity. And again, I don't want to suggest that unless we do it the old way, we're doing it wrong. But it is a vastly transformed methodology. And ultimately, we need to have incentives. So I tell one of my favorite stories about incentives actually is a patent example rather than a copyright example. The invention of the steam engine, the technology that gave rise to the Industrial Revolution and pretty much all of modern society, was not invented in the 18th or 17th century, but was in fact invented in 200 BC. And steam power was used in Roman theaters for special effects and to move stage props. It was invented under a regime of trade secret protection rather than patent protection. The technology was not published, it was not widely disclosed, and as a result of that, the technology behind steam power was essentially lost for two millennia. Think what the world would look like today if we had allowed for steam power and all of the transformations that it brought to have occurred 2,000 years earlier, how that would have changed progress for humanity. And so we see that the risk of de-incentivizing creativity creates a huge risk, right? I can't say it often enough, right? If we have de-incentivized the economic support for creativity, then individuals, students like yourselves, won't see that there's an opportunity to invest in one's career that focuses on creative output, and one will have to have a different kind of day job. When we lose professionals who are deeply engaged in the creative process, who have invested their time and effort to become masters of their skill, we will lose the quality of output. There will still be content, right? People will still create, computers will still create, but the quality, the level, the ability to have experts will disappear from that economy. And if everything is royalty free, if there is no incentive model for folks, then ultimately a generation from now, 2 generations from now, what we will have is a very reductionist model of works that oftentimes just sound and look like each other, and very few opportunities to really develop new works. So copyright has always been about more than just economic incentives. One of the mistakes that the United States has committed that Europe and Asia has gotten right is that copyright is not primarily economic. That was a series of Supreme Court decisions that were made in various eras, as you heard the previous speaker talking about eras in which intellectual property rights are disliked. And so during those eras, copyright law was limited and focused on economic incentives for industry. But if you recall, the first Copyright Act was an incentive for learning, an encouragement for learning, right? It placed authors at the heart of the program. And as an encouragement for learning, it was about the core knowledge and the underlying goals, right? Throughout the US history, writers like Charles Dickens, writers like Mark Twain advocated for a much more expansive understanding of what copyright was to enable society to promote those works. What we have seen as a result is that we need a sea change. We need to focus on re-incentivizing creativity. It starts with storytelling, because all of society is really about the shared narratives that we tell, right? This is how our cultural identity is created. This is how our national identities are created. Everything is about the shared stories that we have. And so reinvesting in those techniques is really essential. And that comes from a core educational model. Again, this is universal. It is education at every level of society in every country. We have to teach a generation of storytellers rather than allowing the machines to tell our stories and reduce the meaning of our stories. Secondly, we need to develop digital literacy so that both as consumers and as creators, people understand the source of content that they're getting, the veracity of the content that they're getting, the context in which content is created. Because if we don't have digital literacy, then we won't have an educated public, we won't have an educated electorate. And without those things, civil society will start to crumble. Third, as a filter, we need to reinvest in critical thinking education. And again, this is a very broad agenda, but we need to rethink how critical thinking is taught, because many of the tools that we use to assess critical thinking can be replicated by AI output. And so students don't have to learn when they can push a button. And so as educators, we have to rethink how we're evaluating and how we're training students so that they don't miss out on the critical education for the critical thinking that they need. And then we have to address the digital abundance challenge, right? It's great that there is so much content out there, but we need to have a different model of economic support and curation so the most important works, the most culturally significant works are protected from that. And we need to essentially value creation. To do that, I have a series of proposals, the first of which is to protect attribution. Under US law, the copyright law does not provide the Berne Convention requirement for attribution rights. And so part of my call is for the United States to finally join the Berne Convention. Technically, we joined in 1988, but as a practical matter, we have not committed to a number of those core requirements. Berne gets it right, and the US gets it wrong on making moral rights, particularly the right of attribution, a central right. What we have seen is that even in areas like Creative Commons licensing, where something is either open source or available to the public, close to 98% of the users of those licenses opt in for a attribution only, at least license. So they may have other restrictions, but the one restriction they all demanded was attribution. When the Creative Commons was created, it was a zero license. There was, all rights were given away. And the users rebelled and went out of their way to select the attribution license instead. It was so powerful that the standard license got changed to the attribution only license. That highlights how important attribution is for creators. It will help us create an attribution economy that people whose work is associated with them and valued for them. It will also help us address the ingestion problem. Right, the extent to which copyright works are being ingested without authorization. Part of the problem is that if there's no attribution right, it is easier to circumvent protections and to claim fair use and to use those works for ingestion. I'll talk separately about protecting ingestion directly, but indirectly, attribution is also very important for that. The second change is, I think, a more aggressive recommendation. And that is that we need to rethink the way copyright works, or that laws work more generally, and to provide for a right that protects a person's work effort, even if that work is not protected by copyright. So under US law, there is a requirement of a modicum of creativity, unlike the notion that we heard in India, where a stone idol can become the copyright owner in limited circumstances. There has to be that creative spark. You heard from Professor Rosen that the creative spark has to be from a human. And for copyright purposes, that may be the right answer. But across Europe and Asia, there's also a database right. There are sui generis protections for non-copyright works that have protection based on the amount of effort that goes into them. And so we need to extend that right in the United States, and we need to recognize that if somebody spends 600 hours fine-tuning a model, putting in prompts, and doing a tremendous amount of work, even though the resulting work is not protected by copyright, it should be protected by law so that the effort is valued and so free riding is reduced, because the free rider problem will otherwise undermine people putting the effort into the work. And so a non-copyright parallel protection, just as exists in Europe and India for database protection, should be expanded in this area to recognize the protections that are essential for work effort. Third, and this is a uniquely United States issue, which is to fix the fair use question. Fair use is very different in the United States than fair dealing in England, for example, and so I won't go into this in great detail, but very simply put, we should not be relying on an 1870s doctrine of fair use to try and answer modern questions about ingestion protection. And instead, I call on the Copyright Office to have a much more robust set of rules and rule-making procedures so that we can expand the examples of fair use. We can reduce the amount of case-by-case ambiguity that exists, because of course ambiguity only increases transaction costs and reduces the ability of creators to create, and quite frankly gives power to those who are better financed, because the threat of litigation is so economically harmful that many creators, even though they're well within their fair use rights, can't afford the challenge. And so by rethinking fair use, using a regulatory agency model to streamline and simplify the process would go a long way to promote creative works and to give answers and concrete understanding within the field. Now, separately, we need to answer the question through statutory solutions as to what ingestion is permitted. And we need to not rely on, again, old notions of fair use, but statutorily answer the question that someone whose works are ingested into a training model needs to be compensated for that, needs to have the right to opt out of that training model. There's plenty of training content. There are plenty of licensors that are selling their content to the training models already. So there's no longer any need for fair use to be the solution to that problem. Finally, and again, this is again a US issue. Again, the United States has cheated in its membership in Berne. Although technically works are created upon fixation as Berne requires, access to the courts require registration for US works, unlike non-US works. And the result is that there is a tremendous amount of time and effort focused on whether a work is registrable. As a US constitutional law educator, it has always struck me that questions as to whether or not a work is registrable don't even rise to the level or case or controversy requirements that should be permitted under federal law, right? There aren't two opposing parties. The Copyright Office has no stake in the output of that claim. And instead, we could have totally abandoned the registration process, do away with millions of dollars of unnecessary transaction costs, let the few cases that actually have economic value make their way through the courts, and instead replace this entirely unhelpful, inappropriate, and very inefficient system with an accredited version of recordation, right? Where the Copyright Office identifies a number of commercial recordation services. The recordation service meets its statutory obligation, and just like a university is accredited to provide that service, and then people go to a recordation agency, your work is recorded, it's digitally filed. If there's ever a lawsuit, then there's an evidentiary record, licenses can be transferred in a way that are followed, and millions, if not billions of dollars are saved, and fights that never need to occur, quite frankly, never happen because there's not actually a commercial challenge over those works. So together, these are the 5 recommendations that I've just made about a statutory right of attribution, about protecting effortness, about reforming fair use, ending registration. And then finally, I guess I did not formally put this as a slide, it was really the first point, that we need to fund arts education, digital literacy, and critical thinking. We need to invest in the infrastructure of knowledge, invest in the infrastructure of creativity, invest in the infrastructure of content in order to protect the next generation of creators. Now, there is a quid pro quo for all of this, right? Some of this will come at the cost to the AI companies. And again, AI has tremendous values for society as well as potential costs. And so the same protection that would go into effortful protection would also create robust database protection for the AIs and their training models. In other words, that the AIs themselves, the same companies that are essentially ripping off the creative artists, are then complaining when other AI companies are ripping them off, stealing their training data, stealing their algorithms. And so again, we need to recognize the effortfulness, the billions and billions of dollars being spent by these companies. And so the same kind of effortfulness protection that would protect our creative artists would also serve to protect those companies. And so again, we get a balance, right? We rebalance the relationship between the tech companies and the creative industries in order to protect both from free riding and unfair activity. And I think if we do those things, then we will create a much more coherent economic model that promotes creativity, that furthers the appropriate use of artificial intelligence that respects intellectual property rights, but most important, respects human creativity, not because it meets a statutory requirement, but because the creators are working to achieve something in the advancement of learning and the marketplace of ideas. And with that, thank you very much, and I look forward to the conversation.
Thank you so much, sir, for your excellent and insightful address. We now open the floor for a brief question and answer session. Participants may kindly share the questions in the chat box.
So Nandini, will you be able to moderate? If you can take up one by one questions?
Yes, ma'am.
Yes. Yeah. Go ahead.
So first question is for NG sir. As you discussed in your 5th point about pharmaceuticals, so the person would like to seek your perspective on the concern that patent protection in the pharmaceutical sector may at times create market monopolies, affecting the access to essential medicines. So how can the patent regime better balance innovation with public health?
Thank you very much. I think I put it in the comment there as well. I think a real collaboration could be have a sustained for the benefit of the public health. And then we can see that in the race for the COVID-19 vaccinations, and that was very much a collaboration between major pharmaceutical companies. Unfortunately, at the end, when it tailed off, because that was such an international public health issue, there was a real collaboration. But in the race of other sort of differential medications, if you like, we don't see a lot of that. So I think we need that enhanced collaboration, and we need a better formula in terms of sharing and protecting the profits, if you like, because at the end of it, it's very much driven by the fees that we get from that as well. So I think there can be the real concern, and we can see that happen before, and do encourage leaders to continue their conversation and dialogue to seek the well-being of the public health. Thank you.
Thank you so much, sir. I hope, Sohani, that answers your question.
Indeed. Thank you so much, sir.
So next question is from Anik Ray for Professor Dr. Jan Garan. What do you see as the biggest challenge in enforcing intellectual property rights in countries where piracy is widespread?
So, sorry, I didn't realize this was for me. So I think as we look, so I'll give a story. So many years ago, I had the opportunity to travel and teach in China. And what struck me during my visit to China, right, which has a reputation for extremely low respect for intellectual property rights. At the time, copyright infringement in the software industry was in the 95%, right? Less than 5% of software products were actually licensed. And as we made our way through the Chinese markets, we realized that every product that used rights of publicity was a licensed product, that there was virtually no infringement from people's name, image, and likeness being used on products. And it really struck me how different that cultural respect was for rights of publicity than for copyright in general. So that tells me a few things. One, attribution matters. And the more we attribute works to people, the more we will be able to sell the moral obligation to respect copyright, because now you're ripping off a person rather than a large institution. I think secondly, we need to create incentives for local markets, right? The US was a pirate nation at its origin. We ripped off the United Kingdom dramatically. It took us decades to protect UK authors in the United States. But what we have seen is globally, the more local works are protected, the easier it is to create a mechanism and incentive to protect both local and global works. And to educate the public that if you are exploiting foreign copyrights, that is depressing the marketplace for domestic copyrights. You can't create a local marketplace if you don't if you are using piracy for the international works, even if you're carefully protecting the domestic works. And so by educating the public and creating reasonable barriers from infringement across both domestic and local, I think you can turn the tide. Maybe not to get to a 0% infringement, but certainly to bring it to more reasonable levels.
Yes, thank you, sir. Sir, in this continuation, there is one more question. Yes, Nandini, if you can just see, I think it is by Anirudh.
Yes, ma'am. So the question is that when it comes to piracy and the culture around it, especially in countries where legitimate means of access to media is limited or non-existent, so how motivated do you think that the lawmakers and courts would be to cement piracy rules clearly, and would it have any value if they do?
So it strikes me that this is a chicken and egg issue, right? The more there is a marketplace for purchased content, the more the market grows. And then the argument that I'm only infringing because I don't have access to the content becomes a less credible argument, right? So we start with creating value, creating marketplaces that local industry can operate in. When I was in Bangalore many years ago, we spent time looking at local language production, right? Because the idea that in Karnataka, for example, the idea that local productions, local languages were being unserved meant that a local producer who could make a local language work would suddenly have a market that wasn't being consumed by US market, wasn't being consumed, quite frankly, by Bollywood market. And so there were opportunities there. Now, again, there is the AI risk that those local markets will be trampled because we can use AI to create those sub markets. But I still think that if a domestic producer understands what a local market can do, they can build up an audience. Again, I think, secondly, I keep coming back to attribution. We see over and over again that people are willing to pay money for artists they support. We see this on, platforms where people, have virtual tip jars and the like. And so by saying you're investing in this artist, again, in music, we see this more than in film, but it's certainly true that people pay for music. They pay to go to a club. They pay to hear a live performance that they otherwise have access to for free because of that relationship with the artist. And so we can use those mechanisms to build a positive cycle. And then once we have the positive cycle, we use enforcement to also raise the cost of infringement.
Thank you. Do we have Mr. Praveen Anand, sir, in the meeting? So we are having two questions for him. So what we will do, those who have asked questions. So dear delegates, we will ask your questions to Mr. Praveen Anand, sir, through email, and then we will let you know the response. Right. Nandini, please take up other questions.
Yes, ma'am. So one question is that how can cross-border enforcement be handled when AI-generated content circulates globally online?
So this question is to whom?
John Gavin, sir.
Okay.
So the challenge is tremendous, right? The ability of a copyright owner in particular, or trademark owner, to police the massive use of AI and the level of infringement has the threat of overwhelming the system, right? This is why we have the Statute of Anne, because the system of the 17th century collapsed under the weight of piracy. And foreign works, in this case Irish works, flooded into the UK markets in the 17th century and overwhelmed the existing system. We are at threat of that happening today. There's no question about it. AI can generate content virtually at will, and global marketplaces can share and redistribute that content, can trade on that content further at will. But it's not the content, it is the consumer that matters, right? So if you look not at how much content is out there, but which works are actually being purchased by people, which works are actually being read, viewed, listened to by people, it's a very different marketplace. When Napster was threatening to upend the marketplace, Napster tried to claim that it was an open marketplace, but only 10% of the work on Napster represented 90% of the traffic. So instead of looking at how overwhelming the market is, the content managers of the world, right, the large media companies, are focusing on where large consumption is and where the economic harms are, rather than just the broad marketplace. And when you do that, you can become more selective and say, okay, this is a work that's highly valuable, and so I can manage that risk. Another example of that is an area that I actually am quite fond of, which is fan fiction, right? So there's a whole world of creative works by the public, the fans, that trade on the trademarks and intellectual property of the creative works that come out of major production companies. All of that is tolerated because it engages the audience with the creative works and doesn't create an economic threat to the marketplace. And so looking at it from what is a true economic threat and what isn't is a way to marshal resources and have some control. But having said that, the potential to simply overwhelm the creative industries is a real one, and we may be getting close to it.
Thank you so much, sir. Sir, the answers were really enlightening and opened new areas of information for all of us. To conclude the plenary sessions, I request Dr. Tanvi Sehgal, ma'am, Assistant Professor, Vivekananda School of Law and Legal Studies, WIPS TC, and co-convener, Center for Intellectual Property Rights, and for the conference, to kindly deliver the vote of thanks.
Thank you so much, Nandini. Respected dignitaries, esteemed speakers, distinguished guests, dear colleagues and participants, as we arrive at the close of this enriching plenary session, it is my privilege to propose the vote of thanks on behalf of VSLLS WIPS TC. First and foremost, I extend my deepest gratitude to the eminent speakers of the plenary session, Mr. Praveen Anand, Dr. Ray, and Dr. John Garron for their insightful perspectives, thought-provoking discussions, and generous sharing of knowledge, which has truly elevated this conference and inspired all of us. I would also like to sincerely thank our collaborator, University of New Hampshire Franklin Pierce School of Law, for their invaluable support and coordination. My heartfelt appreciation also goes to our chairman, Dr. H.C. Watts, Vice Chairman, Mr. Suneet Watts, for providing us with this opportunity to conduct this event, to Professor Dr. Rashmi Salpekar, Dean, VSLLS WIPS TC, and to Dr. Nipun Gupta Jain, Convener for CIPR, for their unwavering support and guidance that has been instrumental in bringing this event to fruition. I would also like to acknowledge the dedicated efforts of the organizing team, faculty members and student coordinators, whose commitment and hard work behind the scenes ensured the smooth conduct of this session. Last but not the least, to all the delegates and participants, thank you for your active engagement and enthusiastic presence. With this, we conclude the plenary session. Thank you once again for being a part of this collaborative endeavor. We look forward to continued dialogue and future partnerships. Thank you.
Yes, so dear delegates, we will meet tomorrow. Okay, tomorrow we are having technical session wherein your views also, we will be, very happy to have your views. And once again, thank you so much, Professor John and Professor
Ray, Dr. Ray.
Ray, yeah, Professor Ray. Thank you so much.
Ma'am, can
So
we
good-
have one group photograph? I would request
Oh, yes. It's a good idea.
all the
Please, go
participants.
ahead.
Yes, ma'am.
Kindly open the video, dear delegates. Done.
Yes, ma'am. Yes, it's done.
Thank
Yes,
you.
thank you so
Thank you
much.
so much.
Once again. Good morning and good night, both.
I hope guests